Good afternoon. It's my pleasure to introduce a distinguished panel to lead off this event. And I'm going to begin by introducing the moderator. Adam Cella is the Senior Special Counsel on the House Judiciary Committee, working on antitrust and administrative law. And Adam comes to us from duties at the Federal Trade Commission, where he was the attorney advisor to Commissioner Christine Wilson. And before that, he was in private law practice. I'm introducing now Congressman Moran, Nathaniel Moran. It represents the 1st District of Texas. He is a freshman. He comes to us from Tyler, Texas, and was on the city council there. And then he became a county judge and was elected to Congress in 2022. So we're pleased to have him. He serves on the Judiciary Committee and Foreign Affairs and the Education and Workforce Committee. Congressman Kevin Kiley represents the California 3rd District. He also is elected in 2022, and he is on the House Judiciary Committee, and as well as chairing a subcommittee on the Education and Workforce Committee. Congressman Kiley began as an English teacher and was a prosecutor in the state of California, and ultimately served as the Deputy Attorney General in the state of California. He served in the California State Assembly and comes to us with a wealth of experience in both intellectual property and criminal and civil prosecution. So it's a pleasure to have both of these distinguished panelists. I give it to Adam. Thank you.
Thank you. I'm going to be very brief before I hand it over to the two distinguished members of Congress and members of the panel that you're actually here to hear talk. And I just want to note two things about these people and how lucky we are to have these two members to come talk about the FTC and antitrust. Both are on the Judiciary Committee, so they have oversight of antitrust. But before being elected members of Congress, who are elected to make our laws, both were involved in the judicial system in different ways. Representative Moran, of course, was a judge, and Representative Kiley was a prosecutor. So when you think about the FTC, where they've always been prosecutors for the last 40 years, even increasingly just prosecutors, but increasingly during the Biden administration, they are also unelected bureaucrats who are making the rules that they then enforce as prosecutors, and increasingly switching hats and acting as judges in the same exact cases they just prosecuted, and then getting a deferential standard on review at the circuit court. And I think this would offend many people who have been elected, or maybe who have sat as a judge and understand, or have been a prosecutor and understand the power of those positions and due process and rule of law in our country, or at least how the process should work. So I'm going to hand it to, we'll start with Representative Moran for any opening thoughts he wants to have on the FTC and bind overreach in the space.
Thanks, and I'll save a lot of what I want to say for questions, because I think that probably what I want to say to you are things that are on your mind, and so we'll leave it to Q&A. But I want to start actually where you finished and just say it never offends me if I'm serving as both the prosecutor and the judge, if I know what end I want to get to, right? And that really helps me out quite a bit. If I could play both Congressman Kiley's role as a prosecutor and my role as a judge, I know I'm going to win the case. And then if I know that I can have deference when it goes up on appeal, then certainly I know I can shape the case the way I want and win on appeal. That is a huge problem. I say it tongue-in-cheek and sarcastically, and I hope you understand that it's a major problem when you're on both sides of the bar itself and serving both behind the bench and in front of the bar. There's just such a plethora of issues right now at the FTC as we look at not just what is going on externally with the decisions being made, but also the management internally. When you look at the turmoil that's gone on inside, the dissatisfaction, the numbers of cases that are being lost, the amount of money that's being spent, which is significantly more than it was before, and I'll cite some of those numbers as we go through today. But you would hope that if you're given more resources and you're exercising kind of a stronger arm in your tactics, that you would at least win more. And we're seeing that that's not the case. And it's because we're not seeing good, efficient uses of those dollars, and we're seeing the wrong standards applied. It's already been mentioned, the consumer welfare standard, which is a great objective standard. But again, if you're wanting to fix the game so that you win, you do not want an objective standard. You want a subjective standard, and you want to fix the rules. And that's the other thing that I really appreciated about the opening comments was when we talk about not just the substance of what gets determined ultimately, but the process by which we are establishing ourselves. You guys all know that really has more to do with the rule of law than the substance of what comes out on the back end. You want a solid process that everybody can trust, where people recuse themselves when they should recuse themselves, when you have the separation of powers between our different branches of government. Then you have surety or confidence in the result itself, because you have surety and confidence in the process. And just like any good case on the trial level, sometimes even when you have the best process in mind, you get it wrong. You get the output wrong, but those are the minor outcomes. It's not the majority of what you see coming out. And unfortunately, at the FTC, we've seen that flip-flopped. And we've seen, I think, the result of somebody who wasn't ready for a management position coming in based on kind of some populist notoriety at the time, that's then going to impose an end that she wants in that agency and the end that she wants in certain cases, and you just can't fit that square box in that round hole, as it were. So we're going to talk about a lot of those issues throughout today. I'll wrap up by just saying that I would like to see us continue to put more pressure on Ms. Khan. Representative Kiley is one of the best at doing that. If you guys have ever watched him ask questions at committee, he's a great prosecutor and still has that rhythm. And if you guys understand that rhythm, you know it when you see Congressman Kiley very effective with his 5 minutes. We need more of that. We need more of the letters that we've been sending this year, and continue to put that public pressure on Ms. Khan to change the direction she's going. I don't anticipate that's going to happen, but at least we keep the limelight on it, and keep some of the temper down on some of the craziness going on over there. Congressman Kiley.
All right, thank you very much. And I think Representative Moran and I, we might be the only two members on both Education and Workforce and Judiciary. So we've gotten to see a lot of the same people in terms of the administration officials. Who we've had Mayorkas, we've had Becerra, we've had Ray and Garland. We've had the head of the DEA. We've had, who else? Cardona, Secretary of Education. We've had a whole host of others. But I got to tell you, Ms. Khan might take the cake when it comes to the abusiveness of her position. I didn't know about her background. I remember before she came and testified for our committee, I was looking it up. She and I went to the same law school. She graduated 5 years after I did. I guess she wrote like a note when she was in law school, and Biden decided to appoint her FTC commissioner based on a note she wrote as a law student. We're seeing her performance reflected not only in the dissatisfaction among her own staff, but also her losing record in court. But I'll just back up just a second and say that I think this is actually a really exciting time when it comes to the sort of work that you all are doing. And thank you for the work you're doing with the Committee for Justice in trying to restore some of the foundational principles of our country, and to try to allow Congress to reclaim its own legislative authority. Unfortunately, Congress hasn't been very good on insisting on that itself. But it's fallen upon sort of public-spirited lawyers and advocates to try to compel that action. And so on a number of fronts now, of course, in the courts, we're seeing this opportunity to really restore the proper balance, the proper principles of separation of powers, and the FTC is sort of maybe one of the most prominent examples of where we have veered away from those principles, and never more so, of course, than under the direction of Ms. Khan, who has basically admitted that she's going out and filing losing cases in hopes of enlarging her power even more and remaking the U.S. economy in the mold of something very different than the market-based economy that we've had for a long time and we've traditionally had. So really appreciate the chance to be part of this panel. Appreciate the work that everyone here is doing, and look forward to finding ways to partner moving forward.
So I just have a few questions, and then we'll definitely take questions from the audience as well. You talked about all the problems with the FTC and antitrust right now in the Biden administration. We obviously have split jurisdiction with the DOJ antitrust division. With all the power given to the FTC, but the two agencies just splitting jurisdiction based on backroom deals, it begs the question, should we even have two agencies? Is it efficient? Is it how the government should, if we weren't making these laws 100 years ago, would we do this the same way today? Is there fixes that Congress can ultimately have to make this a more efficient, fair process?
Yeah, I think one of the fixes has been talked about a little bit, may or may not be in bill form, I don't recall, but moving the jurisdiction for the prosecution of these cases clearly over to the Department of Justice seems to me to be a pretty good way to go, so that you have a distinct separation between the executive and the and this Department of Justice. It really should be determining which ones to move forward with prosecution, and then separate the judicial side of that, the administrative judicial side of that, where you're deciding some of those cases. When I was a county judge, I had to recuse myself from, as soon as I became county judge, any case, of course, that came in any court. I could still practice law a little bit on the side, but I couldn't practice law in courts where, as county judge in Texas, I determined the budgets of all of the other judges in my county. Well, it makes sense for me not to go before them when I'm controlling their budgets. How much less sense would it make for me to actually be able to adjudicate the cases that I actually want to prosecute? And so separating those out, making clear distinction and saying, give the Department of Justice all of the authority to bring the cases in this case. When you look at the numbers of cases the FTC has brought, they've dramatically decreased from the Trump era. So I think one of the years in Trump, maybe fiscal year 20, maybe the last one he did, was 31 cases, and then Khan's done like 15 and 17. And so she's done less. She had more money. I think the money I wrote down was $330 million for the FTC during Trump's era. Now it's up to $430, and then she had asked for like $590, I think, in her budget request. And so she's getting more money. She's actually prosecuting less cases, and then she's losing more of those cases. So she's obviously picking the wrong cases to move forward with, and advocating the wrong standards as she moves forwards with that. So we really need to separate that out. Let the DOJ handle the prosecution of those cases.
Yeah, I mean, that's very interesting, those numbers, because clearly her focus is not on finding genuinely anti-competitive conduct under the traditional consumer welfare standard and existing precedent, but rather trying to push the limits of the law and try to change those standards, and thereby, create changes in the whole economy. So I think those statistics are really revealing. I don't know how much sense it makes to have these two dueling agencies. Anytime you have this sort of multiplicity of regulators, multiplicity of litigation threats, it casts a cloud of uncertainty over business. It tends to have a chilling effect on genuinely pro-competitive or pro-consumer welfare behavior. And what's more, the FTC, of course, gets a much lower standard for preliminary injunctions than DOJ does. And so that also has, sort of multiplies those effects. So it seems to me that's something certainly worth looking at. Not to say that the antitrust division at DOJ is doing a great job in everything either, but, at the very least, there's a little more protection on that side.
Certainly. So you've both mentioned the consumer welfare standard now, and Representative Moran, you wrote a letter touching on the consumer welfare standard back in March. Now, it gets a bad rap from Lina Khan and Jonathan Cantor for being too focused on price. Of course, the consumer welfare standard just focuses on consumers. If it hurts innovation, if it hurts output, if it raises prices as well, it could be illegal. In these years of record inflation that we have seen, how do you go home to your constituents and say, yes, our federal prosecutors are no longer worried about the prices you pay when it comes to antitrust. We're going to focus on whatever the values are of the people in Washington, D.C. How focused are you on just maintaining this consumer-focused antitrust enforcement?
Sure. I mean, very much so. And I think that, like the way you put it is very good. It is, as it says, it's focused on the welfare of the consumer. That's really what we ought to be looking out for. And when you drift away from that, it creates the potential for all kinds of abuse and mischief. And, as we heard in the introduction, these sort of amorphous standards, which, of course, is precisely what Lina Khan wants. I will say, at the same time, it's interesting because there's actually some on our side of the aisle who kind of like some of the things that Lina Khan is doing. And it's one of those odd issues where you get people kind of a certain stripe on both the left and the right who say, well, it's not good when you have these big companies, that they have too much power. And, I sympathize with that instinct in certain ways. But, and I think that there are genuine concerns when you have large tech companies that have so much power over people's lives. But I don't think that it should follow from that we should, have legal actions going after, say, politically unpopular companies just because of their size or because of the way people perceive them. It needs to be grounded in something more concrete, which is why the consumer welfare standard, I think, is a good one. That, okay, if there's a consolidation that's leading to one of these companies having too much market power and they're abusing that market power to the detriment of consumers, that's a very different situation than just saying, well, I don't like this company and I don't like the fact that they're getting bigger. And the reality is, sometimes when you have mergers and acquisitions, it very much redounds to the benefit of the consumer. Like, I think one of the mergers that Lina Khan was challenging was like a medical startup that had the IP but didn't have sort of the operational ability to bring their product to market, and so they were bought by one of the pharma companies. I don't remember which one, and that actually worked to the benefit of the acquirer, the acquiree, and consumers as well. So I think that's why it's really important to have this well-developed concrete standard in law, is that it allows for economic certainty and doesn't allow for sort of the shifting political winds to dictate what is and is not allowed.
I completely agree. And tailoring off just what Mr. Kiley left off on, this idea of certainty. So when I think about your question, I think about how are businesses looking at their future. And without a concrete standard, businesses are less apt to grow, to make investments, to make a little bit riskier decisions that in long term will be good for the consumers, because they're not sure what the standard by which they're going to be judged will be. And so they're less apt to move forward with a potential merger or potential acquisition in a new area, whether or not it's vertical or horizontal, whatever it is. If the goalpost is moving, they're going to say, let's not do that. And so now all of a sudden economic opportunity that would help the consumer down the line can no longer move forward, because businesses are just saying, I don't want to take the risk. I don't want to get sued. Plus a lot of businesses, I just had a business back in my East Texas area that sold all of its pharmacies off. The local pharmacies, if you don't know, independent pharmacists are going out of business, and it was kind of a regional pharmacy group, and they sold to a larger group. And they were telling me, look, we've been through this FTC review before on some things, but this time around, they hadn't been through it in a while, and they said it was so much more expensive to go through the process and so much more onerous on the questions that were being asked, that it almost became to the point where they just want to say, forget it, we don't even want to do it. And their option B was to just divest themselves of that business altogether, because they didn't want to be in the business anymore. And so do we sell out, or do we just get rid of the business? And if they had just gotten rid of the business altogether, then a lot of consumers would have been hurt by that. I also find it interesting that even though they want to move away from the consumer welfare standard, the FTC sort of comes back around when it meets their end, right? In the Amazon issue, that's one of the things they were saying was, well, it's going to, this Amazon Prime is really hurting consumers because the prices are going to be higher, which is not true and didn't turn out to pan out to be factually correct. But that's what they were trying to at least allege, was to say, well, we need to break this up, and because consumers will have to pay a higher price at the end of the day, and then the facts came out and they're like, oh, well, it's a lower price. Okay, well then let's move the goalpost. But they'll invoke it when it meets their end, and that's the problem with any process in government. People need surety of the process so they can make decisions based on that process, and then the facts get applied to that same rule down the line, and let the chips fall where they may. But if the process or the rules change, then businesses don't know what to do, and then they just start getting tight about their business decisions.
So you mentioned the uncertainty and businesses not even attempting mergers. One thing that Jonathan Cantor and Lina Khan brag about is this deterrent effect that they're having. They might be losing cases, but they're stopping a bunch of mergers that they don't even have to review. And you mentioned in your letter, Representative Moran kind of accused her of slow-walking mergers. Yeah. And at the time, you were talking about the ending of early termination. Since then, they put out new HSR filing rules. They're not finalized yet, that by their own estimates would increase the time and legal fees of completing one of these by 3-4x. Massive attacks to businesses directly to lawyers in Washington, D.C. and New York and San Francisco probably. Is there yes, maybe publicly she's losing a bunch of cases and enforcement numbers have fallen, but is there a deeper, more nefarious issue here about what they're actually doing to the economy and the M&A area by just the in-house actions that they're taking around M&A?
Yes. And for any of you M&A lawyers out there, you're the ones that are benefiting from all this. I mean, that's who's really benefiting from this, because now companies are having to pay lawyers a ton of money to navigate through this process. And as a recovering lawyer myself, I would say maybe I don't mind that as a lawyer. Again, that's a selfish way to look at it. Actually, I do. I'm being sarcastic again for anybody watching and can't hear the sarcasm in my voice. But the benefit should be for the consumer and for the economy generally and for capitalism. And so these instances where you have smaller businesses or medium-sized businesses, we're not talking about the tech giants that are affected by this. They can pay all those fees. But for all of these smaller companies that are looking to do a merger that now are captive by the process, the regulation, the burden of the money, it's not worth it to them. And so you can't see innovation moving forward because some of these mergers can't take place. Early termination rule is a good example of that, because you look at cases where there shouldn't be any problem at all, but we're going to make you wait anyway, and we're going to make you produce a lot of documents that you shouldn't otherwise have to produce, and it's just a deterrent for those good mergers to occur.
And I'll just add one thing, which is that the upstream effect of that is it causes VC money to dry up. Because the opportunity to invest is oftentimes predicated on the likelihood of getting acquired and getting a return on that investment. And so if you put all of these administrative barriers to pro-consumer mergers happening, then it will prevent a lot of these startups and innovative enterprises from getting off the ground in the first place. So consumers end up losing out because these inventions and innovations never happen at all.
So consumers losing out is certainly going to happen in the substantive issues that she is raising or not raising, bad substantive issues. You also mentioned, Representative Kiley, I think in your opening remarks, about the internal issues at the FTC, her own staff filling out surveys, government-wide surveys, where they say she doesn't have honesty and integrity, she's not motivating. Both of you mentioned consumer welfare standard, the good work that antitrust enforcement could be doing and how important it is for keeping prices low, for example. This apparently is not happening at the FTC. How do you think that these problems in the FTC, these own staff saying that she doesn't have honesty and integrity, has just kind of passed any criticism from the Biden administration? She's been able to just remain as chair of the FTC despite all of these problems. You're talking about a survey of every FTC employee that wants to fill it out saying these things.
I don't know. It's, we're seeing this, though, in a number of areas of the administration. I mean, there's just a refusal to hold anyone accountable. I mean, we still have the same Secretary of Homeland Security after the border crisis has spun utterly out of control. We still have the same Attorney General whose own FBI director has rebuked his efforts to target parents based on their participation at school board meetings. We have a quote-unquote acting Secretary of Labor who the U.S. Senate has rejected, and yet she still remains there at the helm. If anything, it seems like the extent to which Lina Khan does not have the respect of her own employees is just causing the agency to become more insular and even less responsive to stakeholders and the public. So it's really not a good situation. Honestly, I hope we get her back before our committee again sometime soon, because I don't think that the questions that we raised the first go-round have been answered in any meaningful way.
Statistically speaking, the FTC went from being one of the best rated agencies internally in the prior administration to the worst or next to worst consistently across the board. And that's not members of Congress. So it's not like you can say, oh, this is politically driven. We want to make her look bad. She's done a pretty good job on her own, I think. But internally, in the FTC, her own employees are saying, take these statistics. In 2020, 87% of FTC employees agreed their senior leaders maintained high standards of integrity and honesty. Now it's down to 53%. A respect for senior leaders, 83% in 2020 said that the employees agreed that there was a high level of respect for their leadership. Now it's down to 49% and 44% in the last 2 years. Motivation and commitment, levels of motivation, 80% under the prior administration, now down to 42 and 36% respectively. So that should say something about the internal leadership, at least. One of the things we talk about in our office is the culture. If you're trying to accomplish a goal, you guys all know this, if you're trying to get somewhere from A to B, the team that you've put together to get there from A to B really has to be together. We've got to be rowing together. Even if you are rowing in the wrong direction, for those of us on the outside, if we said, oh, she's on the wrong direction, she's heading the wrong path, at least internally, you would hope that the team was together rowing in the right direction or in the same direction. They're not, and they're very displeased with what's going on. That's what I think led to Commissioner Wilson resigning and saying, enough's enough, just can't deal with it. And so even the employees, top to bottom, every one of them are saying, this is just a mess over here. And to go from the top to the bottom is telling. I don't know why the administration's doubling down, but as Representative Kiley pointed out, they've doubled down on a whole lot of stuff that they shouldn't be doubling down on.
So, Representative Moran, it's a similar question, but you also wrote a letter on the ethics and recusal issues that are happening at the FTC, and it's serious. It was leaked in Bloomberg that a memo leaked from the designated agency ethics official of the FTC that said, Lina Khan, you should not participate in this case. And then it turned out she did participate in the case, risking everything, risking possibly a good case that they ultimately lost, though. This has to do with internal issues. This has to do with not respecting rule of law, but it is more pointed when you have a direct ethical issue that's coming up, and again, completely escaping any scrutiny from her own side of the aisle. What do you think is going on in that respect?
All of us have to be introspective about the way we conduct our business. And we need to find trusted voices out there, nonpartisan voices that we can listen to in times of ethics, because ethics is not partisan, and ethics shouldn't change based on what you're doing or what position you're in. When the designated agency ethics official, who's nonpartisan and neutral, says, you really should recuse yourself in this instance, and then she doesn't, she is, again, doubling down, just like the administration's doing on some policy stuff. She's just basically saying, I don't care. I think some of that comes with maturity, honestly. For a 31, 32-year-old to be put in that spot, really based on that article you were talking about earlier, where she kind of got a spotlight shined on her, and she's really great in front of a camera with communication and very clear, and so she has that public presence about her. There's no question about that. She has a great skill set in that area. but I don't know that the maturity level to run an administrative agency and then also to look internally to say, maybe I should step back. This isn't worth my ethics to go down this road. I don't know that she's gotten to that point in her life, and it's sad, and I'm sorry about that for her, for the agency, and for the businesses that are affected by it.
Yeah, I don't have a lot to add on that one other than to say that this has also been a recurring problem across the administration. The DEA administrator has all kinds of ethical issues with giving no-bid contracts to entities that she has close affiliations with. And so I think it's important that we continue to raise those questions. It's a basic function of oversight.
So you both mentioned problems across the agency. The FTC is supposed to be a bipartisan commission with Republican commissioners. Right now there are no Republican commissioners. They both resigned, partially both of them in protest of Lina Khan's practices. Commissioner Wilson was the last one to hang on. She clearly resigned in protest, very, very loudly in a Wall Street Journal op-ed. Both commissioners accused her of hiding information from them so they couldn't do their jobs. They also complained about just a lot of the anti-capitalist rhetoric that is coming out of the FTC. Commissioner Wilson compared it to pseudo-Marxism and critical legal studies. Is this something that you're also seeing across the administration, or do you think it is even worse or pointed at the FTC, this kind of just anti-capitalist rhetoric that is coming across?
Well, it's certainly part of the kind of prevailing ethos of this administration. Probably the FTC is the tip of the spear, though, in this respect, where there's a very conscious effort to, remake the American economy in significant ways. The Wall Street Journal editorial and the comments from the outgoing commissioner, I think, very much reflected that. But it is, telling when the other commissioners are saying these things. This isn't like just a whistleblower, a mid-level, agency official who is disagreeing with something, but these are the fellow commissioners who are saying this. And, the nature of the FTC, by the way, I think is that they have to have at least two members of every party. And so it's sort of by design meant to be an agency that has this kind of balance. And, commissioners are used to working with folks of differing views. And the fact that you had, both Republicans who it got to the point where they felt the need to resign to bring attention to what's going on, I think that says a lot. And honestly, I'm surprised that it hasn't gotten more attention, what the FTC is doing. I think that there's a lot of people paying very close attention to it, but it's not something that is necessarily in the public consciousness. But it's one of the ways in which this administration's really unprecedented policies and interventions in the economy will be most consequential.
I agree. I like the tip of the spear analogy because I do think the FTC is really the tip of the spear, but it's pervasive across the administration. Let's talk about the non-compete rule that the FTC is pushing, but that's one of several things that I talk about with my businesses that is of great concern to the market and the free market itself. The assault on independent contractor relationships that we're seeing from the administration, the assault on not just the non-competes, but the joint employer rule that's going through the NLRB, the assault on franchisee structure of businesses. Those four things together, coming from different agencies, from the NLRB, the Department of Labor, from FTC, you see it pervasively across the administration where they really don't want competition. They don't want entry to the marketplace. And they do not want a scenario where it's hard to unionize. So let me just tell you, I think all four of those things are coming together to help the labor unions, to say we really would like, ironically, we really would like everybody under the same roof and belonging to the same organization, and we want everybody responsible for that. And so it makes it a lot easier avenue for labor unions to collectively get together, as opposed to 1,000 different Starbucks with 12 people in every Starbucks. Now you got everybody under one roof, and you can have unionization, and that, I think, is the push generally by the administration across the board.
So thinking about that rulemaking, that they're doing. The Congress did not pass a law, say, go make a rulemaking about non-competes. And a lot of states are actually, state legislatures or state attorney generals are actually tackling that problem within their states. What Congress did was pass a law over 100 years ago that said the FTC has power over unfair methods of competition. And Lina Khan is making a rule about unfair methods of competition with non-competes. If this survives judicial scrutiny, she can make any rule that touches on an unfair method of competition. Thinking about all of the issues that the administrative, judiciary deals with administrative space, talking about Chevron deference, about whether they have this power, talking about non-delegation powers, many constitutional problems with this. What do you think the future looks like for rulemaking, for Chevron deference, for the FTC's ability to make any rule about what they call unfair method of competition?
You want to take?
Is that me first or you?
I don't know. But as you were talking, I actually circled on the top of my sheet Chevron standard and Looper. I really hope that the Supreme Court gets this right. I hope that they totally get away from the Chevron deference standard. It's been killing us since it came into play. I also agree with Representative Kiley that we have abdicated our responsibility as legislators. We need to find a better pathway forward. Looper, I hope we'll do away with it. I'm a little bit cautiously optimistic about that. I'm not sure that they'll totally go away from Chevron, but maybe probably narrow it a little bit. I think that's likely what you'll see out of the case. But that Chevron standard and the deference to it is very harmful. It seems like we have a bill in Judiciary, maybe it's Hageman's bill, that is wanting to do away with Chevron, and it may be coming up soon. I think we had some discussion about that. But Representative Hageman has a good bill to do away with the Chevron standard. Would love to see that happen.
Yeah, and I'm glad that Nathaniel brought up the examples of joint employer rule and independent contractor rule because with Lina Khan at FTC and Julie Su at the Department of Labor, I mean what they're doing is really complementary in a sense in this project of remaking the workforce and the very structure of the American economy. And I think it's vitally important to the question that we push back against the attempts to do this through agency rulemaking or through executive decree in every way that we can. And so I'm doing a CRA, Congressional Review Act legislation on this independent contractor rule. For those who aren't familiar with it, it's based on a law in California called AB5, which significantly restricted your ability to work as a freelancer and independent contractor. It could lead to millions of jobs being lost. At the same time, there are a couple of lawsuits that are challenging the agency's authority to issue a rule of that kind. We've also done a CRA on the joint employer rule that actually passed the House with bipartisan support. I think that, and then of course we have the action in the courts, both related to the FTC and its structure and its sort of ability to be judge, jury, and executioner, as well as, of course, the Chevron case and the other attempts to rein in the administrative state. So it's kind of this interesting moment where we have unprecedented abuses of executive authority, while also kind of maybe an unprecedented opportunity to start to change that. So for folks who are involved with this organization, there really could not be a more important time to be doing the work that you're doing.
Thanks. And one more question on just what you just mentioned, Representative Kiley, and then maybe questions to the audience if we have time. We only have a few minutes left. But you mentioned the challenges to the FTC that are going through the courts. The FTC only was found constitutional in a 1935 case called Humphrey's Executor. More recently in Seal of Law, a recent case written by Chief Justice Roberts basically said that's only okay if it looks exactly like the FTC did in 1935, which many people say there's no agency that ever looked like the FTC in 1935. They got it wrong then, and it's definitely wrong now. Is there a future for independent commissions for the FTC, or are the courts going to ultimately reshape what our administrative agencies ultimately look like?
Well, I think the courts are going to, and I think, if you look at, I believe it was Justice Thomas's concurring opinion, he sort of laid that out, and I think that, there are a lot of questions that need to be answered in terms of the authority that these agencies have taken basically for themselves. And so I think that there seems to be interest on the part of the current Supreme Court to continue to go down that road. But it also should not excuse Congress continuing to abdicate its own authority. So, Representative Moran mentioned we have some bills in Judiciary that are aiming to get at that question, but I think that it's important for us to continue to push back in every way we can to administrative overreach. And so I think, perhaps we do need to look specifically at the FTC as well. Maybe there's, an opportunity there to consider some reforms legislatively that could get at some of the abuses that we're seeing.
The other thing I think it's going to take is a president, and both Republican, Democrat side are going to have trouble with this. A president that once in office is willing to give up power. And that is almost impossible to find, no matter which side of the aisle you're on. But we need to queue up in Congress a better process by which we either take back or undo regulatory action and administrative action besides the CRAs. The CRAs are good, but they're near impossible to get through an administration that is the one that's actually doing the rulemaking. It's near impossible. In fact, it's just, I don't know how you do that. I don't know how you actually pass a rule that at the end of the day is going to unroll that rule that the administration put in place. They're never going to see that happen. So we need a president, before he or she realizes the scope and ability for their authority to take place, to say, you know what, we just need to reset the whole game and give Congress their power back and push it away from the executive and do it by structure and by process, and then let that be the guiding star moving forward. I hope we get a president that's willing to do that. Generally, doesn't matter which side of the aisle you're on, once you take office, then you want to assume all that power. You want to do everything by executive authority, and you want to do it through the administrative state. We need somebody that's willing to say up front, I'm going to give it back to the legislative branch.
Just one quick comment on that, because that is absolutely the problem with CRAs, is that you pass it through the House and you in the Senate. We've had a number this year that passed the House and Senate that the president vetoed. There is a proposal that passed through Judiciary, and I think the whole House as well, that would say that it would seek to solve the problem that Nathaniel is pointing at by saying that if there's a rule that has a certain economic impact over a given threshold, then in order for it to take effect, then it has to affirmatively get the authorization by Congress. So I think something like that could actually be a very useful mechanism if we could ever get it passed into law.
I'll look at the organizers. So do we have a few minutes, or are they okay? Yeah. So Alden.
Thank you. Yes, thank you.
Alden Abbott, Mercatus Center. I was general counsel of the Federal Trade Commission in the last administration. Served there 3 times. I also served for 8 years in the Justice Department during the Reagan administration. It's interesting, consumer welfare. Some claim, oh, this is some invented standard. Well, you look at Adam Smith and The Wealth of Nations, who wrote, the interest of a producer ought to be attended to only so far as it may be necessary for promoting that of the consumer. So you can say that the father of modern economics, Adam Smith, is responsible for the consumer welfare standard.
I like that.
Also, just shameless self-promotion, but our center, the Mercatus Center at George Mason University, produced a white paper called Reforming the Federal Trade Commission, which has 12 specific reforms suggested, which could be done internally through internal processes. You need new leadership, but you wouldn't need legislation. So I would commend that to people on Capitol Hill who are interested in just thinking about reforms, again, reforming the Federal Trade Commission. Thank you.
If I might just say thank you for your work at Mercatus on AB 5 and the independent contractor rule. I've cited your paper that just came out a few weeks ago a lot. This was the first attempt to quantify the job losses from that particular bill. That's come at a good time now that we're seeing these harms potentially being nationalized. Thank you.
One question. Sure. I think there's a question. Yeah, right here. Oh yeah, right here. Sorry.
You guys talked about the. You folks talked about the clearance process by which DOJ and FTC work out which agency is going to handle investigation into a particular area of antitrust. And I think most people think of that as an orderly process, but by all reports, there's a turf battle going on between the FTC and DOJ, over who will investigate the supposed threat to competition in the AI industry, particularly the fact that Microsoft has a large stake in OpenAI. Now, of course, both agencies should wait till the turf battle is resolved to do an investigation, but instead, the FTC has essentially launched a quasi-investigation into, again, Microsoft, OpenAI, and also the Google and Amazon stake in Anthropic, and they're doing it under the guise of a 6B industry study. They are allowed to do these broad studies of competition in an industry, but this is, like I say, a quasi-investigation. They're demanding documents from the companies, and it's really, they're sort of thumbing their nose in the face of DOJ. I guess they don't like how the clearance process is going, and I'm wondering what you members can do both to push back against this seeming power grab by the FTC and even perhaps to help DOJ win the turf battle, both because it would result in, I think, a more rational approach to antitrust in a very important industry, II, and also because the number one factor in the clearance process is supposed to be expertise, and it's DOJ that did the Google investigation that has the expertise in search, and search is very closely related to ChatGPT, which is the main focus of OpenAI. So what can you folks do here?
Well, I mentioned earlier, the possible legislation to go ahead and clarify jurisdictional boundaries. That's probably the best way for us to handle that. The second is to just sound the alarm in some of these hearings about what's going on so that folks are aware of it. Those would be the two main things. In the interest of time, I'll keep my answer short, but those would be the two things.
Yeah, and maybe also just do a hearing and bring them both in and, make it awkward for them. Ask them what's going on. It doesn't even need to be the whole Judiciary Committee. It could be the Antitrust Subcommittee that does it, and maybe you don't get Lina Khan and whoever the head, but you get someone there and try to get them to commit on the record to how they're going to work this out. So maybe that's worth something that we can follow up with. It's a good idea.
So that we are at time, so I just want to thank both of the members for coming here and sharing their thoughts with us, and give them a round of applause.
Thanks, everyone.